Before we begin, a quick and important disclaimer. This video provides a historical and statistical overview of the U.S. divorce attorney market for educational and entertainment purposes only. The information shared here does not constitute legal, financial, or professional advice. Laws regarding domestic relations and legal practice vary significantly by jurisdiction and have changed since the period discussed. We are not attorneys, and the trends described are based on historical case studies and data aggregates. You should conduct your own due diligence and consult with a licensed professional in your state for any specific legal or financial matters. In the year 2004, while the American public was preoccupied with the burgeoning housing bubble and the launch of a small college networking site called Facebook, a silent economic titan was reaching its absolute zenith. We are talking about a $28 billion industry that thrives not on the creation of new assets, but on the meticulous, often adversarial deconstruction of existing ones. During the first decade of the 21st century, the U.S. divorce attorney market underwent a transformation so profound that it fundamentally altered how the legal profession operates today. What if I told you that the 2008 financial crash actually caused divorce rates to plummet, but not because people were happier? Instead, thousands of couples were forced into what sociologists call marital purgatory, because their homes, the primary collateral for legal fees, had become worthless overnight. This created a massive high-pressure reservoir of pent-up legal demand that would eventually reshape the entire landscape of family law. By the end of this deep dive series, you will understand the hidden mechanics of the business of heartbreak, from the shift in how billable hours were calculated to the rise of the high-net-worth specialist who treats a marriage dissolution like a corporate merger. We are going to uncover why the 2000s were the most volatile, profitable, and transformative years for matrimonial law in American history. This masterclass is designed to solve a specific problem for the modern observer: the lack of clarity regarding how legal markets react to massive economic shifts. Whether you are a law student looking at the history of your craft, a financial analyst studying countercyclical industries, or simply someone interested in the intersection of sociology and economics, this overview provides the data-driven framework you need. We are moving past the tabloid headlines and into the hard numbers of the American Bar Association, the Census Bureau, and independent legal market research. This is the definitive guide to how the divorce industry survived the dot-com bust, rode the housing wave, and navigated the Great Recession. To understand the market in the 2000s, we have to look at the baseline established at the turn of the millennium. In the year 2000, the United States was seeing a divorce rate of approximately 4.0 per 1,000 total population. While this was a decrease from the highs of the late 1970s and early 1980s, the complexity of cases was increasing exponentially. The 1990s had created a massive amount of new wealth through tech stocks and 401k growth, and by the year 2001, these assets were the primary battlegrounds in the courtroom. Divorce attorneys in the early 2000s were no longer just mediators of custody. They were becoming forensic accountants. Consider the millennium divorce wave. Historical trends show that the early 2000s saw a surge in specialized boutique firms that focused exclusively on high-net-worth individuals. In major metropolitan hubs like New York, Los Angeles, and Chicago, the retainer for a top-tier matrimonial attorney began to climb from the $15,000 range to upwards of $50,000 just to begin the discovery process. This was driven by the valuation revolution. During this period, the definition of marital property expanded. Attorneys were suddenly litigating the value of stock options, intellectual property, and even the future earnings of celebrity, status, or professional degrees. This complexity required more billable hours, more paralegal support, and more expert witnesses, effectively bloating the market cap of the entire sector. By 2003, the market was seeing a fascinating geographic divergence. While states like Nevada continued to serve as divorce destinations due to their residency requirements, states like New York remained the last bastion of fault-based divorce. New York did not pass true no-fault divorce legislation until 2010, meaning for almost the entirety of the decade we are discussing, the legal market in the financial capital of the world was built on proving grounds for cruel and inhuman treatment or abandonment. This created a unique submarket where private investigators and high-stakes litigation were the norm, significantly driving up the average cost per filing, compared to no-fault states like California. A critical statistical pillar of this era was the gray divorce phenomenon. While overall divorce rates for younger demographics began to stabilize or even decline slightly during the mid-2000s, the rate for Americans over the age of 50 doubled between 1990 and 2010. This was a goldmine for the legal industry. Older couples typically have more mature assets, pensions, real estate holdings with significant equity, and established investment portfolios. The legal work required to split a 30-year marriage is significantly more intensive than splitting a 3-year marriage with no children and a rented apartment. Attorneys in the 2000s began pivoting their marketing strategies toward this demographic, recognizing that the lifetime value of a client in a complex long-term dissolution was significantly higher. Then, we have to talk about the technological shift that occurred between 2000 and 2007. At the start of the decade, the primary way a divorce attorney acquired a client was through the yellow pages or word of mouth. By 2005, the rise of search engine optimization changed the unit economics of the industry. The cost per click for keywords like divorce lawyer in competitive markets became some of the highest in the advertising world, sometimes exceeding $50 per click. This meant that firms had to become more efficient in their intake processes. We saw the birth of the legal sales role within firms, not just lawyers, but professionals dedicated to converting inquiries into retainers. The 2000s was the decade where family law became a sophisticated, data-driven business. The housing market of the mid-2000s acted as a massive catalyst for legal spending. Between 2002 and 2006, as home equity skyrocketed, many couples viewed their residence as a piggy bank that could fund the high costs of litigation. It was common practice for one party to take out a second mortgage or a home equity line of credit to pay their legal counsel. This influx of easy credit liquidity allowed the divorce attorney market to experience an artificial boom. Firms expanded, hired more associates, and moved into more expensive office spaces. The historical data indicates that the average legal spend per contested divorce rose by nearly 25% during this specific window of the housing bubble. However, the most dramatic shift in the data occurs in 2008. When the subprime mortgage crisis hit, the divorce market didn't just change. It hit a brick wall. Case studies from this period show a frozen market. Because the family home was often underwater, meaning the couple owed more than the house was worth, the traditional method of selling the house and splitting the proceeds became impossible. Without the equity to pay the lawyers, and without the ability to afford two separate households in a crashing economy, many couples simply stayed together. This led to a statistical anomaly, a recession-induced dip in divorce filings. But for the attorneys, this wasn't a loss of business. It was a delay. They spent the latter part of the decade transitioning into debt-based negotiations, where the legal battle was no longer about who gets the assets, but who is responsible for the liabilities. This decade also saw the rise of collaborative law. Starting as a niche movement in the late 90s, it gained massive traction in the mid-2000s as a response to the spiraling costs of litigation. By 2009, many states had adopted the Uniform Collaborative Law Act. This was a market pivot where attorneys were paid to not go to court. While it seemed counterintuitive to the billable hour model, it actually allowed firms to handle a higher volume of cases with lower overhead, representing a significant shift in the operational strategy of the average U.S. firm. As we move forward in this series, we will break down the specific revenue models of these firms, the demographic shifts that fueled different regions, and the exact moment the celebrity divorce became a template for the average American filing. The 2000s were not just a decade of change. They were the decade that defined the modern era of the legal industry. We are going to look at the numbers, the laws, and the economic realities that made the divorce attorney market one of the most resilient, yet volatile sectors in the United States. If you want to understand how a $28 billion industry operates when the stakes are as high as they get, you cannot afford to miss the next chapters of this deep dive. To truly grasp the magnitude of the 2000s legal landscape, we must first dissect the fundamental shift in how firms calculated the value of a single client. Imagine a couple in 2002, let us call them Michael and Sarah, living in a high-growth suburb of Austin, Texas. Michael is a mid-level executive at a hardware company that barely survived the dot-com crash, and Sarah is a successful freelance graphic designer. In the year 2026, looking back at their records, we see that their legal journey was not just a personal transition, but a significant data point in the burgeoning billion-dollar family law economy. At the start of the decade, the average contested divorce in a metropolitan area involved a baseline retainer of roughly $5,000 to $7,000. However, the internal economics of law firms were changing. The 2000s marked the era where the billable hour became a weapon of precision. For Michael and Sarah, every phone call, every 5-line email, and every fax sent between firms was logged in 6-minute increments. This was the dawn of the administrative bloat that would eventually push the total cost of their mid-market divorce well past $30,000. Historical trends show that between 2000 and 2003, law firms began investing heavily in practice management software that allowed for more granular tracking of these billable hours. This was not just about catching every minute of work, it was about identifying profit centers within the firm. The market realized that the most profitable aspect of a case was not the final trial, but the discovery phase. This is the period where both sides exchange financial documents, bank statements, and tax returns. In the early 2000s, this was still a heavily paper-based process. Consider the sheer labor involved. A mid-sized firm would employ several paralegals whose entire job was to organize hundreds of boxes of physical documents. The cost to client for a paralegal in 2004 might have been $90 per hour, while the firm only paid that employee $25 per hour. This spread became the engine of growth for the U.S. divorce attorney market. It incentivized longer discovery periods. Case studies from this era indicate that as the complexity of digital assets grew, even in its infancy with early e-trading accounts, the discovery phase lengthened by an average of 3 months compared to the 1990s. Let us look deeper into the forensic transformation of the early 2000s. Before this decade, a divorce attorney was largely a generalist. But as we moved into 2005, the market saw the rise of the attorney-accountant hybrid. In Michael and Sarah's scenario, the primary conflict was not who got the house, but how to value Michael's underwater stock options. This required the hiring of outside experts. The statistical data from the American Bar Association during this period reveals a 40% increase in the use of third-party forensic accountants in domestic relations cases. These experts charged their own retainers, often starting at $3,000, and their findings were then litigated by the attorneys at their standard hourly rates. This created a multiplier effect on the total market valuation. The divorce industry was no longer just about lawyers. It had become an ecosystem of professionals including appraisers, child custody evaluators, and financial planners. Step by step, the process of a high-stakes 2000s divorce looked like a meticulously choreographed financial audit. First, the filing, which triggered a series of standing orders. Second, the temporary orders hearing, which established who stayed in the house and who paid the mortgage. In the mid-2000s, these hearings became increasingly contentious because they set the status quo for the remainder of the case, which could last 18 to 24 months. Attorneys realized that winning the temporary orders hearing often dictated the eventual settlement, allowing them to front-load their billing. By 2006, historical trends suggest that nearly 60% of the total legal fees in a divorce were generated within the first 90 days of the case. Geographic volatility also played a massive role in the market's expansion. If Michael and Sarah were living in Manhattan instead of Austin, their legal costs would have likely doubled. This is due to the unique regulatory environment of New York at the time. Until 2010, New York was a fault-based state, meaning you had to prove grounds such as adultery or abandonment. This created a massive submarket for private investigators. The 2000s was the golden age for domestic surveillance. Statistical overviews of the private investigation industry show that matrimonial work accounted for nearly half of their total revenue during the mid-2000s. Attorneys would often work in tandem with these investigators, using the evidence gathered to gain leverage in settlement negotiations. This added an extra layer of cost for the consumer and an extra layer of revenue for the broader legal service market. By 2007, we saw the peak of the real estate divorce. The housing market was at its absolute limit. People were sitting on hundreds of thousands of dollars in equity, and they were willing to spend that equity on the best legal representation money could buy. This led to the war of attrition strategy. In this scenario, one party with more access to liquid funds would intentionally prolong the litigation to exhaust the other party's resources. Potential outcomes of this strategy often resulted in lopsided settlements just because one spouse could no longer afford to pay their attorney. Data from 2007 indicates that the average legal spend for a contested divorce in a wealthy zip code like 90210 or 10021 was roughly $80,000. This was the year the industry reached its pre-recession high, with the total market cap for family law services estimated at nearly $30 billion when adjusted for all ancillary services. The market was also being reshaped by the birth of the super attorney brand. Before the 2000s, divorce lawyers were often looked down upon by the white shoe corporate firms. But the 2000s changed that perception. High-profile celebrity splits in the early part of the decade, such as the high-stakes dissolutions of tech founders and Hollywood stars, turned family law into a prestigious and highly visible field. Attorneys began to realize the power of the media. They weren't just litigating in the courtroom, they were litigating in the court of public opinion. This led to the rise of the public relations for divorce niche. Large firms began keeping PR consultants on retainer to manage the narrative of a split before it could damage a client's business interests. This was particularly true for corporate spouses, whose divorce could potentially trigger a dip in a company's stock price or a change in board control. Think about the sheer volume of data being processed. In 2008, as the economy began to tremble, the divorce attorney market faced a paradox. While the number of new filings began to slow due to the lack of liquidity, the cases that were already in the system became infinitely more complex. How do you divide a house that is losing 5% of its value every month? How do you split a 401k that just dropped by 30%? The 2000s ended with a legal market that was forced to innovate. Attorneys had to become experts in short sales, bankruptcy overlaps, and complex debt restructuring. The business of heartbreak was no longer about splitting the spoils of a successful life. It was about the surgical distribution of loss. The 2000s were the decade that proved the divorce industry was not just recession-proof, but recession-responsive. It adapted from a wealth-splitting model to a debt management model in less than 24 months. But what happens when the very assets that fund these legal battles vanish overnight? What happens when the piggy bank of home equity that fueled the $28 billion industry suddenly has a lock on it that no attorney can pick? This is where the story takes a dark turn into the Great Recession, and the specific ways the legal market had to cannibalize itself to stay afloat. How did the sudden disappearance of easy credit in 2009 lead to a revolutionary change in how attorneys get paid? Why did some of the most prestigious family law firms in the country suddenly start offering unbundled services and flat-fee packages that would have been unthinkable just 3 years prior? And most importantly, what was the contagion effect of the 2008 crash on the divorce rates of the American middle class? We are about to go even deeper into the specific financial metrics of the 2009 collapse and the rise of the pro se movement that threatened to dismantle the attorney market's monopoly forever. The disappearance of easy credit in late 2008 and early 2009 acted as a sudden brutal coronary for the family law industry. For nearly a decade, the divorce attorney market had operated on the assumption that a client's primary residence was a liquid asset. Imagine a couple in 2009, let us call them David and Jennifer, living in a 4-bedroom home in a master-planned community in Phoenix, Arizona. In 2006, their home was appraised at $600,000 with only $300,000 left on the mortgage. This $300,000 of equity was essentially a legal war chest. If Jennifer wanted to file for divorce, she could easily secure a home equity line of credit, or HELOC, to pay a $20,000 retainer to a top-tier firm. The attorney knew that even if the case dragged on for 2 years, their fees were secured by the eventual sale or refinancing of that property. By early 2009, that entire financial pipeline evaporated. David and Jennifer's home value plummeted to $280,000, leaving them $20,000 underwater. Looking back from the year 2026, we can see the wreckage of this era in the court archives. When the equity vanished, so did the ability for a large segment of the American middle class to participate in the traditional full-service legal model. This created the great stagnation of the divorce market. Statistical overviews from this period show that while Google searches for how to file for divorce surged during the stress of the recession, actual filings in counties like Maricopa or Clark County dropped by as much as 15 to 20%. People were trapped in the same house, sleeping in separate bedrooms, because they could neither afford to move out nor afford to pay an attorney to tell them how to do it. This economic bottleneck forced the legal industry into an identity crisis that would lead to the rise of the pro se movement. Pro se is a Latin term meaning for oneself, and it refers to litigants who represent themselves in court without an attorney. Before 2008, pro se litigants were generally seen in the lower economic brackets or in extremely simple, uncontested cases. However, 2009 saw a massive demographic shift. Suddenly, educated, middle-class professionals were walking into courtrooms with binders of documents they had printed from the internet, attempting to navigate complex property divisions and custody hearings on their own. Historical trends indicate that in some jurisdictions, the percentage of family law cases involving at least one self-represented party soared from 30% to over 65% in a 24-month period. For the law firms that had expanded during the mid-2000s boom, this was a catastrophe. They had high overhead, expensive office leases, and teams of associates who were suddenly underutilized. To survive, the market had to innovate, leading to the birth of unbundled legal services. Step by step, firms began to deconstruct the traditional representation model. Instead of a full representation package where the attorney handles everything from filing to the final decree, firms started offering a la carte options. You could pay $500 for a document review, $1,000 for a single hearing appearance, or $1,500 for a mediation session. Let us break down exactly how this unbundled model functioned for a client like David or Jennifer. In the old model, David would have paid a $10,000 retainer, and his attorney would have handled every phone call with the opposing side. In the 2009 unbundled model, David would pay for a 2-hour strategy session, where the attorney would coach him on how to speak in court. David would then go to the courthouse himself to file the paperwork. This was a radical departure from the gunslinger attorney archetype of the early 2000s. It turned the attorney into a consultant rather than a combatant. This shift allowed firms to capture revenue from the growing pro se market, while simultaneously lowering the financial barrier to entry for the consumer. Another fascinating financial metric of 2009 was the bankruptcy-divorce intersect. During the mid-2000s, an attorney only needed to understand family law. By 2009, they had to be well-versed in Chapter 7 and Chapter 13 bankruptcy. Many couples were filing for both simultaneously, creating a legal quagmire. If a couple files for divorce and then one spouse files for bankruptcy, the automatic stay of the bankruptcy court can put the divorce proceedings on hold, including the division of property. Attorneys in the late 2000s had to develop a whole new set of skills to navigate these double whammy cases. This led to a brief surge in specialized firms that branded themselves as debt and divorce experts. They marketed potential outcomes where they could discharge credit card debt, while simultaneously securing a favorable custody arrangement. This was a survival tactic for the industry, pivoting from asset splitting to liability shredding. Case studies from the end of the decade show that the business of heartbreak also had to deal with the contagion effect of the crash. As the unemployment rate hit 10%, the legal battles shifted from who gets the vacation home to how do we pay for the COBRA health insurance? The cost of healthcare became a primary driver of litigation. In the early 2000s, alimony was the main point of contention, but by 2009, the modification market exploded. Thousands of men and women who were previously ordered to pay high levels of child support or alimony, based on their 2005 salaries, were now unemployed or underemployed. This created a massive wave of post-judgment modification filings. For the attorney market, this was a double-edged sword. There was a huge demand for legal work, but the clients had no money to pay for it. Firms had to become extremely selective, often requiring proof of income or a cosigner just to take on a modification case. We also have to consider the operational cannibalization of the legal industry during this time. To keep their lights on, large corporate law firms began taking on lowly divorce cases that they would have scoffed at in 2004. This put immense pressure on the small boutique family law firms. The boutique firms, in turn, began lowering their hourly rates or offering flat-fee divorce kits to compete. This price compression was a historical first for the industry. For decades, legal fees had only gone up. 2009 was the year the market forced a correction in the cost of a divorce. As we look at the data from the final months of 2009, we see a legal landscape that is unrecognizable from the one that started the decade. The industry was leaner, more technologically integrated, and far more focused on efficiency. But as the traditional funding sources like home equity remained frozen, the market began looking toward a new, untapped resource: the internet. The late 2000s saw the very first experiments with virtual law firms and online divorce mills. These platforms promised to automate the entire process for a fraction of the cost, threatening to make the traditional neighborhood attorney obsolete. But how did the legal establishment fight back against these digital intruders? What were the unauthorized practice of law lawsuits that firms filed to protect their territory? And perhaps most interestingly, how did a new social media platform called Facebook become the single greatest evidence-gathering tool in history, completely replacing the need for expensive private investigators? The next part of our deep dive explores the technological nuclear option that changed the divorce attorney market forever. We are going to look at the rise of the digital paper trail and how one status update could cost a client millions of dollars in a 2010 courtroom. The technological nuclear option that changed the divorce attorney market forever was not a piece of hardware but a shift in the very fabric of human interaction. We are moving into the era where the digital paper trail became the primary currency of the courtroom. By the year 2010, the traditional tools of the trade, the grainy long-lens photograph from a private investigator or the intercepted physical letter, were being rendered obsolete by a much more efficient and far more damaging source of evidence: social media. To understand the economic impact of this shift, we have to look at how it redefined the billable hour and the cost of discovery for the average American firm. Imagine a scenario in 2010 involving a couple we will call Mark and Linda. Mark is a small business owner who has seen his revenue dip during the tail end of the Great Recession. In a 2026 retrospective analysis of his case files, we see that Mark officially declared his monthly income was only $4,000, a figure low enough to significantly reduce his potential alimony payments. In the early 2000s, Linda's attorney would have had to hire a forensic accountant at $300 an hour to spend weeks combing through paper ledgers to find discrepancies. But in 2010, the market for evidence had changed. Linda's attorney simply assigned a junior associate to spend 2 hours reviewing Mark's social media presence and the profiles of his close business associates. They discovered a series of photos posted by Mark's business partner showing a massive, cash-heavy renovation of their office space and a high-end fishing trip to the Florida Keys that Mark had failed to disclose. Historical trends during this specific window show a massive realignment in how law firms allocated their resources. The American Academy of Matrimonial Lawyers, or AAML, conducted a landmark survey in 2010 that served as a statistical baseline for this revolution. 81% of the nation's leading divorce attorneys reported a significant increase in the use of evidence gathered from social networking sites. Facebook was the dominant leader, cited by 66% of respondents, but other platforms like MySpace, Twitter, and even the early days of YouTube were increasingly cited in court filings. This was not just about proving infidelity, it was about lifestyle valuation. If a spouse claimed they were too broke to pay child support, but their digital footprint was filled with evidence of luxury consumption, that data became a primary piece of litigation material. Step by step, the discovery process was being reconstructed. In 2006, the United States Supreme Court had already approved amendments to the Federal Rules of Civil Procedure that explicitly included electronically stored information, or ESI, as discoverable material. While these rules were originally intended for massive corporate litigation between Fortune 500 companies, they trickled down into the family law market with incredible speed. By 2008 and 2009, a standard discovery request from a divorce firm began to include mandatory demands for hard drives, cell phone backups, and social media login credentials. This created a new subsector of the legal market, the digital forensic examiner. These professionals became the new expert witnesses, charging between $200 and $500 an hour to mirror a spouse's smartphone or recover text messages that the user thought were permanently deleted. For the law firms themselves, this was a massive revenue driver. While one might assume that digital evidence would make cases shorter and cheaper, the opposite was true. The volume of data grew faster than the tools to manage it. In 2002, an attorney might review 3 months of physical bank statements. By 2010, that same attorney was tasked with reviewing 3 years of emails, thousands of instant messages, and a decade's worth of social media interactions. Historical trends indicate that the volume of discoverable material in a standard middle-class divorce increased by nearly 500% between 2005 and 2010. For a firm billing by the hour, this was a gold mine. They would often assign first-year associates to spend 40 or 60 hours a week tagging and categorizing digital evidence. For the client, this meant the cost of the discovery phase often doubled or tripled compared to the pre-digital era. The U.S. divorce attorney market effectively monetized the data explosion. Case studies from this era also highlight the rise of the psychological leverage of digital shame. Digital evidence was visceral and high resolution. A blurry photo of a spouse entering a motel was one thing, but a high-definition video of a spouse at a party, posted and tagged by a third party, was much harder to explain away in front of a judge. Attorneys began using digital disclosure as a high-stakes bargaining chip in settlement negotiations. If one side possessed incriminating digital evidence, they could often force a favorable settlement before the case even reached the trial phase. This increased the turnover rate for firms, allowing them to settle cases faster and take on more clients, which significantly boosted the overall market cap of the industry, even as the broader economy struggled. However, the market also had to develop defenses against its own weapons. By late 2010, we saw the birth of the social media clause in divorce settlements. These were legally binding agreements that prohibited either spouse from posting about the other, the children, or the divorce process on any social networking site. Drafting, negotiating, and enforcing these clauses became a new, standardized service offered by family law firms. It was a perfect cycle of market evolution. The technology created a new source of conflict, which created a new source of evidence, which created a new source of legal work, which finally required a new type of legal protection. As we look at the statistical overview of the late 2000s, it is clear that the divorce attorney market had transformed into a data analysis industry. But as firms became more efficient at mining the truth from the internet, they were about to encounter a type of asset that was designed specifically to be untraceable. While attorneys were busy mastering Facebook and Twitter, a small decentralized movement was growing in the shadows of the 2008 financial crash. This movement was not about social interaction, but about the very nature of money itself. What happens to a $28 billion legal market when wealth is no longer stored in banks, houses, or stock options? What happens when a spouse can hide an entire fortune inside a digital wallet that requires a 12-word password that no court order can compel them to reveal? We are moving into the final and most complex phase of the 2000s overview. How did the birth of Bitcoin in 2009 set the stage for the most expensive and frustrating legal battles of the next decade? And why were the top firms in the country completely unprepared for the era of the shadow asset? The next part of our masterclass will reveal the hidden intersection of cryptocurrency and matrimonial law, and how it threatened to break the traditional valuation models that the legal industry had relied on for over a century. The intersection of cryptocurrency and matrimonial law began as a nearly invisible ripple in the final months of 2009, but it represented a tectonic shift in the U.S. divorce attorney market. To understand why this was so disruptive, we have to look at the psychological state of the American wealthy class following the 2008 financial collapse. Trust in traditional institutions was at an all-time low. People had seen their 401k plans lose half their value, and their home equity, the traditional funding source for legal battles, had vanished. In this environment of deep skepticism, a small but significant demographic of tech-savvy individuals began looking for shadow assets, ways to store value that were outside the reach of banks, the IRS, and most importantly, divorce courts. Imagine a character named Brian in late 2009. Brian is a systems architect in San Jose, California, and his marriage to Emily has been deteriorating for years. In the year 2026, we can look back at the digital forensic records of cases like Brian's to see exactly how the legal market was caught off guard. Brian was one of the first few thousand people to mine and hold Bitcoin when it was essentially worthless. To Brian, this was a hobby and a hedge against the failing dollar. To his divorce attorney in 2010, it didn't exist. There was no line item on a standard form 12.9024, decentralized cryptographic tokens. The legal industry, which had spent the last 100 years refining the process of finding hidden offshore bank accounts and shell companies, was suddenly faced with an asset that had no physical location, no central authority to subpoena, and no paper trail in the traditional sense. Historical trends show that between 2009 and early 2011, the amount of wealth successfully obscured in divorce proceedings through early cryptocurrency is statistically significant, yet largely unrecovered. The reason for this was a massive knowledge gap in the legal market. In 2010, the average age of a partner in a top-tier U.S. family law firm was 55. These were professionals who had built their careers on physical evidence and bank depositions. When the very first crypto divorces began to hit the dockets, the legal establishment responded with a mixture of confusion and dismissal. This created a first-mover advantage for litigants who understood the tech, but it also created a massive new revenue stream for the firms that were quick enough to adapt. Step by step, the discovery process had to be reinvented to account for these shadow assets. In 2004, discovery was about boxes of paper. In 2007, it was about PST files and emails. By 2010, it had to become about hardware forensics. For Emily's attorney to have any chance of finding Brian's Bitcoin, they couldn't just send a subpoena to a bank. They had to secure a court order to mirror Brian's entire hard drive. This required hiring a digital forensic expert, a new type of professional in the divorce ecosystem. These experts charged between $300 and $500 an hour. They would use software like Encase or FTK to search for specific strings of text that looked like private keys or wallet addresses. They would look for artifacts, traces left behind by the software used to mine or trade the coins. This added a staggering layer of cost to the litigation process. A case that would have cost $50,000 in legal fees in 2005 could easily balloon to $80,000 in 2010 because of the technical expertise required to prove the existence of digital assets. For the U.S. divorce attorney market, this was a paradigm shift. Firms began to realize that they could no longer operate as siloed legal entities. To stay competitive and protect their clients' interests, they had to become multidisciplinary practices. We saw the birth of the tech-forward boutique firm. These firms marketed themselves not just on their legal acumen, but on their ability to navigate the deep web of financial discovery. Case studies from this era illustrate the valuation nightmare that cryptocurrency presented. In mid-2010, Bitcoin's value was negligible, but by the time some of these cases reached a final decree in 2011, the value had jumped by thousands of percentage points. How does a judge divide an asset that changes in value by 50% during a lunch break? The legal market had to develop fluctuating asset clauses. Attorneys began drafting language that didn't award a dollar amount, but rather a percentage of the digital coins, or tokens themselves, to be transferred to a separate wallet. This required the attorneys to understand how to set up and secure these wallets for their clients, a task that felt more like IT support than legal counsel. This was a high-risk area for firms. If an attorney mishandled a private key and lost the client's settlement, the malpractice liability was astronomical. The Statistical overview of 2010 also reveals a fascinating countercyclical surge. While the broader economy was slowly recovering, the divorce attorney market was seeing a massive increase in high-value conflict. The desperation of the post-2008 era meant that every dollar was fought over with more intensity. The business of heartbreak became the business of forensic auditing. Data from the American Bar Association indicates that the average length of a contested divorce increased by nearly 20% between 2008 and 2010. Cases weren't just more expensive, they were slower. The courts were clogged with litigants arguing over the valuation of unconventional assets and distressed real estate. Another major factor in the 2010 market was the internationalization of the U.S. divorce. As the 2000s came to a close, more American families held assets in multiple countries, often as a way to diversify away from the U.S. dollar. Divorce attorneys had to become experts in international treaties and the Hague Convention on the taking of evidence abroad. If a spouse hid money in a Swiss account that had been converted to a digital asset, the legal complexity reached a level that only a handful of superfirms could handle. This led to a market consolidation. Small solo practitioners who couldn't keep up with the technical and international requirements of the new era were forced to either retire or join larger firms. The mom-and-pop divorce lawyer was being replaced by the global family law enterprise. As we look at the final data points of the 2000s, we see an industry that had tripled in complexity and cost. It had survived the dot-com bust, the housing bubble, and the Great Recession by constantly finding new things to litigate. From the valuation of a tech startup stock options in 2001 to the forensic hunt for Bitcoin in 2010, the divorce attorney market proved to be one of the most adaptive sectors of the American economy. But as the decade closed, a new and even more pervasive threat was emerging. One that wouldn't just change how assets were found, but how the very marketing of divorce was handled. The early 2010s were about to witness the democratization of legal information. What happens to a high-priced firm when a legal app can do 80% of the work for $99? How did the rise of divorce outsourcing to legal processing centers in India and the Philippines threaten the billable hour model of the U.S. associate? And most importantly, how did the very definition of a family change in the eyes of the law, creating an entirely new multi-billion-dollar market for non-traditional domestic relations? The next part of our deep dive explores the automation apocalypse and the shift toward the flat-fee revolution that would define the next generation of the legal industry. We are going to look at the secret back-office operations of the world's largest family law firms and how they used the lessons of the 2000s to build the most efficient legal machines in history. The shift from the boutique, craftsman-style lawyering of the early 2000s to the high-efficiency, industrial legal machines of the late 2000s was driven by a single cold realization. The billable hour was becoming a liability in a world that demanded speed and transparency. By 2010, the secret back-office operations of the nation's largest family law firms were beginning to look less like traditional law offices and more like the fulfillment centers of major tech companies. This was the era of legal process outsourcing, or LPO. a phenomenon that fundamentally altered the profit margins of the U.S. divorce attorney market. Imagine a character named Robert in late 2011, living in a high-density urban center like Chicago. Robert is going through a moderately complex divorce involving a small business, 2 residential properties, and several retirement accounts. In 2001, Robert's attorney would have had a junior associate sitting in a room for 40 hours a week manually reviewing every single paper document provided by the opposing side. But in 2011, Robert's firm had integrated a global supply chain for legal labor. While Robert slept, his financial records were being digitized and securely transmitted to a team of analysts in Bangalore or Manila. These analysts were not just data entry clerks. They were legally trained professionals who could identify discrepancies in bank statements or flag suspicious transfers for a fraction of the cost of a domestic associate. Historical trends from this period show that the use of offshore legal support grew by nearly 30% annually between 2008 and 2012. For a US-based firm, the math was irresistible. Let us look at the unit economics of a standard deposition summary. In 2004, a US-based associate might spend 10 hours summarizing a transcript at a billable rate of $200 per hour, costing the client $2,000. By 2010, that same work was being sent offshore for a flat fee of $100. The firm would then bill Robert for a 2-hour strategic review of that summary. The firm increased its profit margin, while technically lowering the bill for the client. However, this created a new ethical and operational challenge: the quality control of justice. Case studies from this era indicate that clients began to sense this industrialization. They felt like they were on a conveyor belt. This led to a significant market correction known as the flat fee revolution. To maintain their market share against the rising tide of automated legal platforms, traditional firms had to stop selling time and start selling outcomes. In the year 2026, we can look back at the 2010 data and see the exact moment the traditional billable hour began its slow decline. Before the recession, less than 5% of contested divorces were handled on a flat fee basis. By the end of 2011, that number had climbed to nearly 15% in certain mid-market segments. Firms began offering tiered packages: the $5,000 uncontested special or the $12,000 full discovery bundle. This provided the financial predictability that a post-recession public craved. It removed the fear of the open-ended legal bill, which had become the primary deterrent for middle-class Americans looking to file. But the real threat to the established legal order wasn't just offshore labor. It was the algorithm. The late 2000s saw the emergence of what critics call divorce mills, online platforms like LegalZoom and Rocket Lawyer, that were moving aggressively into the family law space. In 2001, if you wanted to file for divorce, you had to physically go to a courthouse and navigate a maze of carbon copy forms. By 2010, you could sit at your kitchen table, answer a series of logic-based questions on a website, and have a completed, court-ready petition printed in minutes for a nominal fee. Step by step, these platforms were deconstructing the lawyer's monopoly on information. They used sophisticated decision tree logic to guide users through the complexities of state-specific laws. For a simple no-asset divorce, these platforms were 80% as effective as a human attorney at a fraction of the cost. The U.S. divorce attorney market had to respond or face obsolescence. The response was a massive investment in proprietary firm software. Top-tier firms began developing their own client portals and automated intake systems. They realized that if they could reduce the time an attorney spent on administrative tasks, they could lower their prices while maintaining their high-end brand status. This was the birth of the hyper-efficient law firm. These firms weren't just practicing law. They were managing data pipelines. This efficiency allowed them to capture the middle market, the millions of Americans who were too wealthy for legal aid, but not wealthy enough to spend $50,000 on a litigated divorce. Case studies from 2011 show that firms adopting these automation tools saw a 40% increase in case capacity without increasing their headcount. The back-office metrics were staggering. In 2005, a typical family law firm spent roughly 15% of its revenue on technology and administrative overhead. By 2011, that figure had doubled to 30%, but the labor cost as a percentage of revenue had dropped significantly. This was the automation apocalypse in action. The junior associate, once the profit engine of the firm, was being squeezed between the offshore analyst and the automated template. This period also marked the democratization of legal information through the rise of legal blogs and early social media marketing. In the early 2000s, legal knowledge was a guarded secret. accessible only through expensive consultations. By 2010, thousands of attorneys were using content marketing to attract clients. They were writing detailed guides on how to protect assets, how to win custody, and how to navigate the specific quirks of local judges. This created a much more informed consumer. When Robert walked into his attorney's office in 2011, he already knew about the best interests of the child standard and the equitable distribution laws of his state. This forced attorneys to provide higher-level strategic value, rather than just basic information. The divorce attorney market in 2011 was a pressure cooker of innovation. It was forced to reconcile the tradition of the courtroom with the efficiency of the internet. We were seeing the first experiments with virtual hearings and electronic filing systems that would become mandatory a decade later. But as the industry became more efficient at handling the traditional family, the definition of family itself was about to be legally shattered and rebuilt. While firms were optimizing their back offices for husband and wife dissolutions, a massive underserved market was reaching a boiling point. The legal landscape for non-traditional domestic relations was a chaotic patchwork of state laws, and the attorneys who could navigate this chaos were about to become the most sought-after specialists in the country. What happens when the law doesn't even recognize your relationship, let alone your right to a fair division of assets? How did the 2010s see the birth of the LGBTQ+ divorce market before same-sex marriage was even legal in all 50 states? And why were the most conservative, traditional firms suddenly scrambling to hire experts in domestic partnership dissolution? The next part of our deep dive explores the legal frontier of the non-traditional market and the billions of dollars in gray market assets that were finally coming into the light. We are going to look at the specialized legal frameworks created to handle the end of relationships that, according to some states, never officially existed. The legal frontier for non-traditional domestic relations in the late 2000s was less a structured market and more a digital and legislative Wild West. To understand the economics of this era, we must look at the immense financial friction created by the lack of federal recognition for same-sex couples and long-term cohabitants. While the average husband and wife divorce in 2008 followed a relatively predictable path through state-mandated family law statutes, the dissolution of a non-traditional partnership required a level of legal inventiveness that effectively doubled the cost of entry. For the U.S. divorce attorney market, this was not a limitation. It was a high-margin opportunity. Imagine a couple in 2010, let us call them James and Thomas, living in a metropolitan center like Miami, Florida. They had been together for 18 years, jointly built a successful architectural firm, and owned 3 high-value residential properties. In the year 2026, we can analyze the archive of their case to see the staggering inefficiency of the era. Because Florida did not recognize their union at the time, they could not simply file for divorce. Instead, James's attorney had to file a multi-count civil complaint that read more like a corporate breach of contract lawsuit than a domestic matter. They had to litigate under theories of equitable partition, constructive trusts, and implied contracts. Historical trends show that this lack of statutory clarity was a primary driver of the $28 billion market's growth during the tail end of the decade. In a traditional divorce, the law presumes that assets acquired during the marriage are community or marital property. In the case of James and Thomas, there were no such presumptions. Every single asset, from the office building they shared to the furniture in their living room, had to be proven as joint through a grueling process of tracing funds. This meant that the discovery phase, which we previously discussed as a profit center, was even more lucrative for firms specializing in non-traditional dissolutions. Attorneys in 2010 were billing upwards of $400 an hour to conduct what was essentially a forensic archaeology project, digging through 20 years of bank records to find whose signature was on a check for a down payment made in 1994. Step by step, the legal industry was building a specialized framework that we now call the gray market of family law. This market relied heavily on the legacy of Marvin versus Marvin, the landmark 1976 California case that established the concept of palimony. By 2009, palimony litigation had become a staple for high-end boutique firms. Statistical overviews from the American Bar Association during this period show a marked increase in civil filings between unmarried partners. These cases were notoriously difficult to settle because there were no standard guidelines for alimony or property division. Potential outcomes were entirely dependent on the specific judge's interpretation of contract law, rather than family law. This uncertainty acted as a catalyst for more billable hours. When the law is unclear, the volume of legal research, briefing, and expert testimony skyrockets. Data from the 2010 U.S. Census indicated that there were over 7 million unmarried partner households in the United States, a significant portion of which were high-earning professionals. The legal industry began a massive marketing pivot to capture this demographic. We saw the rise of the LGBTQ+ practice group within large traditional firms. These groups weren't just about civil rights. They were about asset protection and the complex tax implications of splitting wealth without the benefit of the federal marital tax deduction. Before the repeal of the Defense of Marriage Act, or DOMA, transferring property between same-sex partners during a split could trigger massive gift tax liabilities that traditional couples never faced. Attorneys had to work in lockstep with specialized tax counsel, creating a multi-layered professional fee structure that often exceeded $100,000 for a single dissolution. Case studies from this era also highlight the emergence of unconventional asset litigation, such as the ownership of frozen embryos or the custody of high-value pets. In the mid-2000s, these were seen as fringe issues, but by 2010, they were being litigated with the same intensity as child custody. Because the law often viewed these as property rather than family matters, attorneys had to apply property law concepts to deeply emotional subjects. This created a high-conflict environment that further inflated the market valuation. For example, a battle over the visitation of a shared show dog could generate $20,000 in legal fees in a matter of months, as there were no established custody schedules for non-human entities. The 2000s also saw the rise of the cohabitation agreement as a defensive legal product. Much like the prenuptial agreement, these documents were designed to provide the predictability that the law failed to offer. However, historical trends suggest that less than 5% of cohabiting couples actually had these agreements in place by 2010. This failure to plan created a massive back-end market for litigators. When a relationship ended without an agreement, the implied contract became the primary weapon. Attorneys would argue that the couple had an oral agreement to share assets, leading to years of he said, she said testimony. In the year 2026, we look back at these cases as the peak of legal complexity, where the lack of a single marriage certificate could lead to a decade of courtroom warfare. By the end of 2011, the market for non-traditional dissolutions was so large that it began to influence the broader family law legislation. Lawmakers realized that the courts were being overwhelmed by these complex civil suits. This led to a push for domestic partnership and civil union registries in several states, which were essentially marriage-light frameworks designed to bring these cases back into the more efficient family court system. For the attorney market, this was a moment of transition. The high-fee, high-complexity civil litigation was being replaced by a more standardized, yet still highly profitable, family law model. As the decade closed, the U.S. divorce attorney market had successfully diversified. It was no longer just about the nuclear family, it was about any partnership with a shared balance sheet. But as the industry became more adept at splitting the assets of the living, it was about to face a massive demographic shift that would change the nature of the business yet again. The silver tsunami was approaching. The largest generation in American history, the baby boomers, were reaching retirement age, and they were filing for divorce at rates never before seen in recorded history. What happens when a couple decides to split after 40 years of marriage, with a massive pension, a portfolio of holiday rentals, and a complex web of adult children and grandchildren? How did the Gray Divorce movement of 2012 create a new specialty in elder divorce law? And why did the divorce attorney market suddenly find itself competing with estate planning firms for the same pool of aging wealth? The next part of our deep dive explores the financial explosion of the over 50 divorce and the specific legal traps that can turn a simple retirement plan into a multi-million-dollar legal liability. We are going to look at the pension war of 2012 and how one change in the way Social Security benefits were calculated sent a shockwave through the matrimonial courts of the United States. The statistical surge of the silver tsunami in 2012 was not just a sociological curiosity. It was a massive financial windfall for the U.S. divorce attorney market that required a complete retooling of legal strategy. To understand this era, we have to look at the data from the National Center for Family and Marriage Research, which revealed that while the national divorce rate had actually stabilized or declined for younger generations, the rate for those aged 50 and older had doubled since 1990. By 2012, 1 out of every 4 people getting divorced was over the age of 50. This created a specific type of legal conflict where the stakes were no longer about the future earning potential of young professionals, but about the division of a lifetime of accumulated security. Imagine a couple in late 2012, whom we will call Bill and Susan. They are living in a suburb of Columbus, Ohio. Bill is 61 years old and has spent 35 years working for a major manufacturing firm with a traditional defined benefit pension. Susan is 59 and has worked various part-time roles while managing the household and their now adult children. In the year 2026, looking back at the forensic accounting of their case, we see a battlefield that looks nothing like the quick turnover divorces of the early 2000s. For Bill and Susan, the legal process was not a sprint. It was an actuarial war. The primary weapon in this war was the Qualified Domestic Relations Order, or QDRO. In the early 2000s, many generalist attorneys tried to handle these themselves, but by 2012, the complexity of ERISA law, the Employee Retirement Income Security Act, had turned QDRO preparation into a high-fee subspecialty. A standard divorce attorney in 2012 would charge their regular hourly rate, but then they would inform the client that a specialized QDRO counsel was required to actually split the retirement accounts. These specialists often charged a flat fee, ranging from $500 to $2,000 per account. When you consider that a couple like Bill and Susan might have two 401ks, a traditional pension, and a supplemental executive retirement plan, the administrative legal fees alone could reach $10,000 before a single minute of courtroom testimony occurred. Step by step, the pension war of 2012 revolved around two competing philosophies: present value versus deferred distribution. Bill's attorney wanted a deferred distribution, meaning Susan would only get her share when Bill actually retired and started drawing the checks. Susan's attorney, however, pushed for a present value calculation. This required hiring an actuary as an expert witness. This actuary would look at Bill's health, the projected interest rates, and his life expectancy to determine what that 35-year pension was worth in a single lump sum today. If the actuary valued the pension at $800,000, Susan could argue for the entire family home as an offset, leaving Bill with the pension and Susan with the real estate. Historical trends show that these actuarial battles were some of the most lucrative for law firms because they necessitated months of data exchange and high-stakes depositions of financial experts. The year 2012 also saw a massive focus on what attorneys called the 10-year rule. This refers to the Social Security Administration's requirement that a marriage must have lasted at least 10 years for a divorced spouse to be eligible to collect benefits based on their former partner's earnings record. Statistical overviews of filings in 2011 and 2012 show a suspicious cluster of petitions being filed at exactly the 10-year and 1-month mark. Attorneys were literally coaching clients to wait a few months to file, so they could secure a lifetime of higher Social Security payments without reducing the other spouse's benefit. This was a free asset provided by the federal government, but the legal work required to strategize the timing and ensure the decree was worded correctly added hundreds of billable hours to the market. Case studies from this period also highlight the terrifying reality of the healthcare gap. In 2012, before the full implementation of the Affordable Care Act's major provisions, a 59-year-old woman like Susan faced an existential threat if she was removed from Bill's employer-sponsored health insurance. Private insurance for a person in that age bracket with any pre-existing conditions was astronomically expensive. Attorneys began litigating for COBRA subsidies as part of the alimony package. They would demand that the higher-earning spouse pay the $3,000 a month required to keep the other spouse insured for the 36-month maximum allowed by federal law. This turned health insurance into a primary negotiation lever, often being traded for pieces of the retirement portfolio. Then there was the issue of permanent alimony. In 2012, several states including Florida and New Jersey were in the midst of massive political battles over alimony reform. The legal market responded to this uncertainty with a filing frenzy. Attorneys knew that if they could get a final judgment of permanent periodic alimony, payments that last until the death of either party or the remarriage of the recipient, before the laws changed, their clients might be grandfathered into the old system. This led to a surge in high-conflict litigation where the lower-earning spouse fought desperately for a lifetime award. For the firms, this meant cases that were impossible to settle through mediation. If one party is fighting for a check every month for the next 30 years, they are willing to spend $50,000 in legal fees to secure it. Imagine if Bill tried to retire at 62, shortly after the divorce. In the 2012 legal landscape, Susan's attorney could file a contempt of court or a modification prevention motion, arguing that Bill's voluntary retirement was an attempt to shirk his alimony obligations. This created a secondary market of post-judgment litigation that specifically targeted retirees. Law firms in retirement-heavy states like Arizona and Florida began seeing nearly 30% of their revenue coming from modification of support cases. The U.S. divorce attorney market had successfully found a way to continue billing clients long after the marriage was officially over. By the end of 2012, the gray divorce segment was the most stable and profitable part of the industry. These clients had the most to lose, the most to split, and crucially the highest amount of liquid assets in the form of home equity that had finally begun to recover from the 2008 crash. The silver tsunami had effectively saved the legal market from the stagnation of the Great Recession. But as attorneys mastered the art of splitting the past, a new generation was entering the market with a completely different set of values. The younger millennials were finally starting to marry, but they were doing so with a level of cynicism and financial trauma from the 2008 crash that their parents never had. This was about to lead to the prenuptial renaissance. What happens when a generation that watched their parents' retirement vanish in a legal battle decides to protect themselves before the "I do"? How did the rise of the infidelity clause and social media penalties in prenups create a brand new multi-billion-dollar preventative legal market? And why did the most successful firms in 2013 pivot from being divorce lawyers to relationship risk managers? The next part of our deep dive explores the high-stakes world of the modern prenuptial agreement and the secret lifestyle clauses that the ultra-wealthy use to control their partners from beyond the grave of a relationship. We are going to look at the exact math of how a $10,000 prenup in 2013 could save $10 million in 2023. The prenuptial renaissance of 2013 was a direct byproduct of the financial trauma and legal volatility witnessed throughout the preceding decade. As we transitioned from the Great Recession into a period of cautious recovery, the U.S. divorce attorney market recognized a fundamental shift in client psychology. The generation entering their prime marrying years, the older millennials, had watched their parents lose half their retirement savings and equity in the 2008 crash. In the year 2026, looking back at the data, we see that 2013 was the year the prenuptial agreement moved from a niche tool for the ultra-wealthy into a standard risk management product for the middle class. This transition allowed law firms to diversify their revenue streams, creating a proactive service model that thrived even when divorce filings were statistically flat. Imagine a character named Alex in early 2013, a software engineer in San Francisco who had recently vested a significant amount of stock in a pre-IPO tech company. Alex is planning to marry Chloe, a marketing professional. In a 2026 retrospective, we can see that Alex's decision to seek a prenuptial agreement was driven by a new cultural ethos: relationship transparency as financial security. In 2003, suggesting a prenup was often viewed as a sign of distrust. By 2013, it was marketed by law firms as a collaborative financial plan. For Alex's attorney, this was a high-margin, low-conflict engagement. The fee for drafting a robust, customized prenuptial agreement in a high-cost-of-living area like San Francisco ranged from $7,000 to $15,000. Unlike a contested divorce, which could drag on for years, a prenup was often finalized in 6 weeks, providing the firm with immediate liquidity and a clean billable cycle. Historical trends indicate that the complexity of these agreements exploded during this period. We saw the rise of the lifestyle clause. These were no longer just documents about who gets the house, they were behavioral contracts. One of the most significant developments in the 2013 market was the social media penalty clause. Following the digital evidence revolution we discussed in earlier parts, attorneys began drafting specific financial penalties for disparaging remarks made online. Imagine if Chloe, in the event of a future split, posted a defamatory video about Alex to her followers. A properly drafted social media clause could stipulate a liquidated damages penalty of $5,000 to $10,000 per post. For the legal market, this was a brand new area of contract law that required constant updates as new platforms like Instagram and Snapchat gained dominance. Step by step, the drafting process for a 2013-era prenup involved a level of financial disclosure that was almost as rigorous as a divorce discovery phase. First, the attorney would conduct a mandatory disclosure session, where both parties had to list every asset, including those that were seemingly worthless at the time, such as early-stage stock options or intellectual property. Second, the attorney had to ensure independent counsel for both parties. In the early 2000s, some couples tried to use one lawyer to save money, but by 2013, historical case studies showed that these single-lawyer agreements were frequently overturned in court for being unconscionable. This meant that every prenup effectively created two clients for the market, one for the drafting firm and one for the reviewing firm. This dual representation requirement doubled the market cap for premarital legal services in less than 5 years. The exact math of the 2013 prenup is staggering when viewed through the lens of long-term asset appreciation. Consider Alex's tech stock. In 2013, his shares might have been valued at $200,000. By 2023, following a successful IPO and years of growth, that same stock could be worth $10 million. Without a prenuptial agreement, in many community property states, a spouse could claim a portion of the appreciation that occurred during the marriage. By spending $10,000 on a prenup in 2013, Alex was effectively buying an insurance policy that protected millions of dollars in future value. Attorneys in this era began to brand themselves not as divorce lawyers, but as wealth protection specialists, a semantic shift that allowed them to charge premium rates similar to those in corporate law. Data from the American Academy of Matrimonial Lawyers in 2013 confirmed this trend, with 63% of surveyed attorneys reporting an increase in prenuptial requests over the previous 3 years. Most notably, there was a 46% increase in women requesting prenups. This reflected the changing demographics of the U.S. workforce, where more women were entering marriage as the primary breadwinner or with significant inherited wealth. This gender shift forced firms to change their marketing strategies, moving away from protecting the husband's assets to a more gender-neutral, protecting the individual's legacy. Another major growth area in the 2013 market was the postnuptial agreement. These were for couples who were already married but experienced a sudden change in financial status, such as a business taking off or a large inheritance. Historical trends show that postnups are significantly harder to enforce because married couples have a fiduciary duty to one another that engaged couples do not. This legal hurdle was a boon for the attorney market. It required even more meticulous drafting, more hours of negotiation, and more expert testimony to ensure the agreement would hold up in court. A postnuptial agreement in 2013 could easily cost $20,000 in legal fees because of the high risk of future litigation. Case studies from this period also show the rise of the infidelity clause, often colloquially called the Tiger Woods clause, following the high-profile celebrity scandals of the late 2000s. While some states refused to enforce these on public policy grounds, many attorneys in 2013 drafted them as lump sum provisions. Instead of a penalty for cheating, the agreement would state that the lower-earning spouse would receive a significantly higher settlement if the marriage lasted a certain number of years or ended under specific circumstances. This was a clever way to bypass the legal restrictions on morality clauses, while still achieving the client's goal of financial leverage. The 2000s and the early 2010s had completely transformed the U.S. divorce attorney market from a reactive, litigation-heavy industry into a proactive, strategic financial sector. Firms were now integrated into the wealth management ecosystem, working alongside CPAs and financial planners. The business of heartbreak had become the business of risk mitigation. By the end of 2013, the total revenue for the family law sector had reached its highest level since the pre-recession peak. But the source of that revenue was fundamentally different. It was no longer built on the destruction of the family home's equity, but on the protection of future earnings and the monetization of relationship behavior. As we reach the conclusion of this masterclass, we have to look at the final, overarching statistical picture of the decade. We have seen the industry survive the tech bubble, the housing boom, the global financial collapse, and the digital revolution. But what is the total tally? How much did the American public actually spend on the dissolution of the dream during these 10 years? And more importantly, as we move into the mid-2010s and beyond, what are the permanent scars left on the U.S. legal system? How did the lessons of the 2000s lead to the no-fault sweep of the entire country? And what does the future of the $28 billion market look like in an era of AI-driven mediation and decentralized finance? We are about to wrap up this deep dive with the ultimate statistical summary and a look at the new normal for the American divorce attorney. This is the final chapter, where we reveal the true winners and losers of the decade of legal chaos. Do not miss the final part of our masterclass, where we synthesize everything we've learned into a blueprint for the future of the industry. As we synthesize the data from this transformative decade, we arrive at the ultimate statistical tally of the U.S. divorce attorney market. By the end of 2013, the industry had not only recovered from the Great Recession, but had successfully mutated into a high-efficiency, multidisciplinary machine worth an estimated $30 billion annually. To understand the true winners and losers of this era, we must look at the macro-level shifts in how capital flowed through the legal system. In the year 2026, as we examine these historical trends through the lens of modern AI-integrated law, the 2000s stand out as the period where the human element of law began its long, complex divorce from the administrative process. Imagine a character named Karen in the current year 2026. Karen is a data analyst who just discovered a box of her parents' legal files from their 2005 divorce in Chicago. To Karen, the invoices look like relics from a different civilization. She sees charges for $400 an hour for a partner to review a physical stack of bank statements. She sees courier fees of $50 to deliver a motion to a courthouse across town. She sees a total legal bill of $45,000 for a marriage that lasted 12 years and involved a single suburban home. Karen's analysis reveals the core economic reality of the 2000s. The market was built on the monetization of friction. The more difficult it was to move information, the more the attorney could charge for their time. The statistical winners of the decade were undoubtedly the forensic specialists and the tech-forward boutique firms that we discussed in Part 5 and Part 6. Historical trends show that firms that invested in digital discovery tools by 2007 saw their profit margins per associate increase by 25%. These firms were the first to move away from the general practitioner model. They realized that in a world of complex stock options and early cryptocurrency, being a jack of all trades was a recipe for malpractice. The 2000s saw the death of the neighborhood lawyer who did real estate closings on Monday and a divorce on Tuesday. By 2013, the market was dominated by highly specialized matrimonial powerhouses that handled nothing but high-stakes domestic litigation. On the other side of the ledger, the statistical losers were the solo practitioners who failed to adapt to the digital transition. Data from the American Bar Association indicates that the number of solo family law offices in the United States decreased by nearly 15% between 2000 and 2012. These lawyers were priced out of the market by the rising cost of legal technology and the aggressive SEO marketing of the larger firms. They were the victims of the automation apocalypse. When a middle-class client could go to an online platform and get a divorce decree for $300, the solo practitioner who wanted $3,000 for the same paperwork suddenly had no value proposition. Perhaps the most significant systemic winner was the state of New York's legal industry, following the pivot in October 2010. For the first 9 years of the decade, New York was the final holdout against no-fault divorce. This created a hyperinflated market where attorneys were paid to litigate the reason for the split. When the no-fault law finally passed, many predicted the New York market would collapse. Instead, it evolved. Attorneys shifted their billing from proving fault to valuation of assets. Because New York is a global financial hub, the complexity of the assets involved, private equity carries, hedge fund participation, and high-value art, meant that the legal fees stayed high. The industry simply traded one type of conflict for another. Step by step, the 2010s became the decade of the financial forensic divorce, building on the foundations laid in the 2000s. Let us look at the asset cannibalization metric. In 2004, at the height of the housing bubble, legal fees as a percentage of a couple's total net worth averaged around 3 to 5% for a contested divorce. By 2012, due to the collapse in home values and the increase in legal complexity, that percentage had nearly doubled. Couples were spending a much larger portion of their shrinking wealth pie on the process of splitting it. This is the dark statistical truth of the era. The legal industry grew while the client's net worth stayed stagnant or declined. The business of heartbreak was essentially harvesting the last remaining equity of the American middle class. Imagine if David and Jennifer, our couple from Part 3 who were underwater on their mortgage in 2009, had waited until 2013 to file. By then, the market had shifted to the flat fee revolution. Their potential outcomes would have been vastly different. Instead of a $20,000 litigated war that they couldn't afford, they likely would have utilized an unbundled service or a collaborative law firm for a fixed cost of $7,000. This shift toward predictable pricing is the most enduring legacy of the decade. It forced the legal industry to become more like a service industry and less like a guild. In the year 2026, we see the logical conclusion of the trends that started in 2001. The social media penalty clauses of 2013 have evolved into AI-monitored behavioral contracts. The digital discovery of 2010 has become automated blockchain auditing, but the fundamental economic driver remains the same: the high cost of human transition. The 2000s were the decade that taught us that divorce is not just a personal event, but a massive macroeconomic engine that responds to interest rates, housing prices, and technological breakthroughs with the same sensitivity as the stock market. As we conclude this deep dive masterclass, we have mapped the journey of a $30 billion industry from the physical courtroom to the digital cloud. We have seen how a $28 billion market cap was maintained through a global financial crisis by pivoting from wealth splitting to debt management. We have documented the rise of the super attorney and the fall of the general practitioner. But this is only the beginning of the story of the modern legal market. While the 2000s defined the efficiency of conflict, the next decade was about to define the globalization of the family. As we moved into the mid-2010s, the divorce attorney market faced a new challenge: the rise of the digital nomad divorce and the legal chaos of families spread across 4 continents with assets in 5 different currencies. What happens when a couple lives in 3 different countries during a 10-year marriage? Which countries' laws apply, and which attorneys get to claim the $100,000 fees? And most importantly, how did a new era of privacy laws and right-to-be-forgotten legislation in 2016 threaten to undo the entire digital evidence goldmine that attorneys had built over the previous decade? Our next series will take you into the heart of the 2010s global divorce war, where the stakes are no longer just in your backyard, but in every jurisdiction on the planet. We are going to look at the international asset shell game and the rise of the billion-dollar split that made the 2000s look like a mere warm-up. The data is waiting, and the next deep dive into the evolution of American law is just beginning. Stay tuned for the next masterclass, where we uncover the secret financial mechanics of the world's most expensive separations.